that generous introduction, Judy, and warmest thanks to you and the tremendous staff of the Radcliffe Institute for all the things large and small that you have done to make this such a wonderful year. I also want to recognize my fellow fellows. Thank you so much for your camaraderie, conversation, and inspiration over the course of the year. It's been a real treat getting to know you and your work. I'm grateful, too, for the research assistance of my 2 law school RAs, Jake Newman and Alice Kalina, as well as my 3 Radcliffe research partners, undergraduates Jean Chang, Kyle Kim, and Eva Shang. My law school faculty assistant, Amanda Sigalski, is simply a treasure. Many thanks, Amanda. And I'm also thankful for the insight and support of my editor at Harvard University Press, Joyce Seltzer, who is helping to marshal this project to completion for publication by HUP next year. And warm thanks as well to all the colleagues, students, and friends who've come to hear me speak today. Of course, I'm indebted to my family. My husband, Paul, and my son, Josh, and my sister-in-law, Wendy, are all here, and nothing would be possible without them. Now, speaking of family, for the project that I'm going to discuss today, I owe the most to my brother and co-author, Jordan Steiker, a law professor at the University of Texas. Jordan could not be here today, so I've created a slide to recognize his contribution and our partnership. As you can see, our collaboration goes back a long way. Here we are at ages 9 and 10, along with our more recent professional photos. We no longer wear identical outfits, but I like to think that our work has not suffered for that. So our project addresses what Justice Harry Blackmun called the American experiment with capital punishment, by which he meant the Supreme Court's more than 40 years of constitutional oversight of the death penalty. Our book will take its place within a broad literature on capital punishment in the United States and abroad. Many of these works are of the pro-con variety, which explore moral, religious, political, and practical arguments for and against the continued use of capital punishment. In addition, historians, political scientists, and sociologists have made major contributions to our understanding of changes in punishment practices over time. Our project, we hope, will fill a gap in this literature by providing a better understanding of the role of law and legal institutions, particularly the Constitution and the Supreme Court, in the American death penalty story, both past and future. One significant misapprehension that we hope to correct is the idea that what is most anomalous about the United States with respect to capital punishment is the fact that the US has retained the death penalty when all of our peer nations, all of the other Western democracies, have abolished it. Yes, as Judy said, it is true that we are in the top 5 executioners in the world, up there in an unusual club of countries for us, along with China, Iran, Saudi Arabia, and Iraq. However, the rest of the world, including those countries, has either simply abolished the death penalty or simply retained it. What is actually most unusual about the United States is what Justice Blackmun called our experiment, with neither abolition nor retention, but rather with regulation, the American attempt to rationalize and reform the practice of capital punishment through intensive top-down judicial regulation under the Constitution. Our book is the story of this experiment, which began in the late 1960s and continues to this day. We trace the complex, ever-changing contours of the Supreme Court's constitutional regulatory project. We analyze its success or failure on its own terms, its unanticipated consequences, hence our title, Unpremeditated, and its implications both for the future of the American death penalty and for the future of constitutional regulation more broadly, especially with regard to other hotly contested social issues like abortion and gay marriage. Now, this is a big project, and I won't even try to summarize all the parts of it here today. Rather, I'll try to do 3 things. First, I'll offer some background on the death penalty in the United States before the Supreme Court stepped in, to give you a sense of how big a change that was. Second, I'll describe how and why the Supreme Court got into the game of constitutional regulation of the death penalty. And finally, I'll give my best answer to the question that's most commonly asked of me: what is the future of the American death penalty? So let's start with some background on the death penalty before the constitutional turn. Today, anyone who reads the papers knows that the most important questions about capital punishment in the United States today are answered by the Supreme Court. Can juveniles get the death penalty? What kind of evidence must be considered in capital sentencing hearings? Can you get a death sentence for a crime other than murder? In fact, exactly a week from today, the Supreme Court will hear arguments about whether current procedures for lethal injection run an unacceptably high risk of cruelty in light of a streak of gruesomely botched executions last year in which condemned inmates choked and gasped and took hours to die. Many executions around the country are on hold, awaiting the Supreme Court's ruling, which will be handed down by the end of June. But it wasn't always so. In fact, for most of American history, the Supreme Court played essentially no role in regulating capital punishment. Rather, the death penalty was understood to be a tool of local criminal justice, invoked by local officials to address distinctively local concerns. This is a painting of Mary Dyer being led to the gallows to hang for the crime of heresy here in Boston in 1660. Dyer was a Quaker who repeatedly defied her banishment from Puritan Massachusetts Bay Colony, knowing that she did so upon pain of death. Today, we understand Dyer's fate as a warning about the dangers of religious intolerance. In fact, you can find a statue of Mary Dyer in front of the Massachusetts State House downtown with the inscription, "Witness for Religious Freedom." However, in her own time, Dyer's sentence was a warning of a different kind. Her execution dramatically conveyed the deepest commitments of the Puritans, who viewed Quakerism as incompatible with their model of Zion in America. You can see the pervasive impact of Puritan theology on capital punishment in the colony's list of capital offenses, which reflected as much influence from the Bible as from English common law. One could be executed here in Massachusetts not only for heresy, but also for idolatry, blasphemy, man-stealing, and the offense of being a rebellious son. Hear that, Josh? The use of capital punishment in colonial Massachusetts to promote religious values contrasted sharply with its use in southern colonies and later southern states to protect the slave economy. Whereas adultery, sodomy, and witchcraft featured prominently in the crimes resulting in execution in 17th century New England, property crimes and crimes by slaves received greater attention in southern colonies. For example, Virginia expanded its capital code to include numerous offenses related to the tobacco trade. And South Carolina made it a capital crime for slaves to maim or even to bruise whites, or to encourage other slaves to run away. Slaves convicted of murdering their owners or of plotting revolt were often subject not merely to ordinary death by hanging, but to even more terrifying and gruesome forms of execution, such as burning at the stake or breaking on the wheel. This is a depiction of the execution by burning at the stake of a slave convicted of a slave revolt in South Carolina in 1712. In addition, the corpses of slaves executed for revolt might also be displayed in cages or dismembered to intensify and extend the terrifying spectacle. Today, of course, we don't punish heresy or slave insurrection at all, much less with death. However, two key features of this era of such outmoded practices have persisted until quite recently. First, the death penalty remained for centuries primarily a matter of state and local prerogative. Second, the officials who controlled the most important aspects of death penalty practices, legislatures, governors, attorneys general, and prosecutors, all came from the political branches of government, meaning that they were either elected themselves or served at the pleasure of an elected official. Until the Supreme Court constitutionalized the practice of capital punishment, a process that began in earnest in the 1960s, the death penalty simply was not a subject of top-down national regulation, and certainly not by federal courts. To be sure, the federal government has always controlled its own capital statutes and prosecutions, including, as Judy reminds us, the federal prosecution of the Boston Marathon bomber taking place downtown as we speak. But prior to the Supreme Court's intervention, the federal government never claimed authority over state death penalty practices, and the states have always been where the central action is with regard to capital punishment. The federal government is really a bit player in the national death penalty drama. Of the more than 1,400 executions that have taken place nationwide since 1976, only 3 have been conducted by the federal government. The takeaway point is this. By making federal constitutional law the most important source of guidance for death penalty practices across the country, the Supreme Court fundamentally altered the pathways of change for the American death penalty. Power moved from states and localities to the federal government, and from the political branches to the courts. Now, the absence of top-down national regulation did not mean that the American death penalty remained static until the Supreme Court intervened. On the contrary, death penalty practices changed substantially over time, and often in the same direction across multiple jurisdictions. From the founding era of the late 18th century to the constitutional era of the late 20th century, the American death penalty experienced at least 4 fundamental transformations. First, the number of crimes eligible for death narrowed substantially. In early American history, many crimes were punishable by death. Not just murder, but also rape, kidnapping, robbery, burglary, assault, and theft, among many others. During the 1800s, however, the wide scope of the death penalty shrank considerably. The invention of the penitentiary, another American innovation, and a growing belief in the possibility of rehabilitation through social isolation, penitence, and labor, supported the work of reformers who sought to limit the ambit of the death penalty. By the start of the Civil War in 1861, no northern state authorized death for any offense other than murder or treason. Now, it's important to note that while southern states, too, narrowed their capital codes during this period, they did so less dramatically and limited the restrictions that they did make to crimes committed by whites. Indeed, most of the death penalty reforms that I'm going to be talking about happened later, less completely, or not at all in the South, a geographical divide that I will return to in a moment because it's an important part of my story. The second significant reform of the death penalty was the decision of American jurisdictions to give juries discretion to withhold the death penalty, even for offenders convicted of murder. Prior to this innovation, the death penalty was mandatory upon conviction of a capital crime. The only possible escape from execution was by clemency or pardon by the governor or the president for federal offenders, who held the same discretionary powers as English monarchs. But such unpredictable mercy led juries in the days of mandatory death sentences to spare the lives of sympathetic defendants by voting to acquit them of capital crimes, even in the face of compelling evidence of guilt. Concerns about jury nullification motivated many death penalty supporters to join opponents in authorizing jury discretion in capital sentencing. The third major change in death penalty practices addressed the location of executions. During the 19th century, executions were moved from public to private spaces and from local to centralized places. Public executions, such as the hanging of Mary Dyer on Boston Common in colonial Massachusetts, reflected the belief that executions served important spiritual and pedagogical functions. In the 19th century, however, an emerging middle class that cultivated a sense of its own refinement began to regard public executions as the province of the baser elements of society. Public executions were no longer viewed as religious, edifying rituals, but instead as raucous, coarsening spectacles, although it's not entirely clear that the actual practice changed all that significantly. By the turn of the 20th century, the vast majority of death penalty states had passed private execution statutes. The last public execution in America, which took place in Kentucky in 1936, corroborated many of the concerns of the practice's critics. The spectacle was attended by a crowd of nearly 20,000, served by vendors selling hot dogs, popcorn, and drinks. Time magazine reported that tipsy merrymakers rollicked all night. Kentucky abolished public executions in 1938, and none has taken place since. Finally, the fourth and final wave of change in death penalty practices was the replacement of the gallows with other purportedly more humane methods. To the gallows. The successive development of new modes of execution in the United States stands in contrast to England, which kept hanging as its mode of execution until it abolished the death penalty in 1969, and to France, which used the guillotine until it abolished the death penalty in 1981. But in the United States, because local sheriffs oversaw executions in the United States for most of the 19th century, the risk of inexpert hangings was substantial, leading to prolonged death by strangulation or alternatively to decapitation. Thus, American jurisdictions repeatedly experimented with new modes of execution to render the process less painful and less visibly destructive of the body. Various states adopted, this is more or less in the historical order, the firing squad, the electric chair, the gas chamber, and now today, lethal injection. Whatever we might think of these modes, these innovations were all promoted in their time as humanitarian interventions to produce less painful and mutilating executions. But today, as effective lethal injection drugs become harder to find because drug companies are increasingly reluctant to sell them for execution purposes, some states are once again seeking to develop new methods of execution or to resurrect old ones. Last year, Tennessee brought back the electric chair in the event that lethal injection drugs cannot be obtained. And this year, Utah brought back the firing squad for the same purpose. This past week, the state of Oklahoma approved an entirely new execution method, one that's never been used anywhere before, death by nitrogen asphyxiation, invented, I have to say, by a professor of criminal justice, to take the place of lethal injection should the Supreme Court rule against it in next week's case. The continuing saga of evolving execution methods illustrates well the nature of the substantial changes that death penalty practices have undergone throughout much of American history. These changes have been the product of statewide rather than national regulation, and they've been driven by politicians rather than by courts. Now, state legislative initiatives to reform death penalty practices no doubt were influenced by forces beyond state borders, for example, by the work of national abolitionist organizations and by the experience of other states. However, these external influences were lateral rather than top-down. The national government and the federal courts played no substantial role in any of the waves of changes in death penalty practices until the Supreme Court's constitutional intervention in the 1960s and 70s. This brings me to my second point. At this point, you may be wondering, what led the Supreme Court to intervene after so long a period of constitutional quiescence? Good question. Here is where I want to return to the geographical divide that I referenced earlier. Although the waves of death penalty reform that I just described reached across the country, change often came more slowly, if at all, in the South. The history of the American death penalty has been one of broad-based change over time, yes, but it has also been a history of profound regional division that is still clearly visible in death penalty practices today. Scholars and activists often refer to the swath of currently active death penalty states in the American South as America's Death Belt, a play on the Bible Belt that describes essentially the same region. The distinctive Southern embrace of capital punishment is in large part a product of the South's historical practice of chattel slavery and of slavery's enduring racial legacy long after the end of the Civil War. Indeed, one of the strongest predictors of a state's propensity to conduct executions today in the 21st century is its history of lynch mob activity more than a century ago. Given this connection, it should be no surprise that today a map of active death penalty states, that is, states that have conducted at least one execution in the past 15 years, is predominantly a map of the Deep South. Not a single state from that region is among the 25 states that have either abolished capital punishment or have not carried out an execution in the current century. Now, the South's disproportionate use of capital punishment began early in American history. The South has conducted by far the most executions of any region during every historical period except for the 1600s, the first century of European settlement, when overall populations were small, Black inhabitants few, and executions of any kind rare. After the end of that century, the South would consistently outstrip every other region in total number of executions, the majority of which were of Black people. At first, Southern colonies embraced the death penalty because of the perceived needs of the developing slave economy. Slave owners wanted the state's help in disciplining the enslaved population, both to promote economic productivity and to protect the increasingly outnumbered white population from much feared violence by slaves or revolt. For slaves who were already in captivity, the threat of imprisonment was not thought likely to serve as much of a deterrent. But even after slavery was abolished through the Civil War, the South continued to champion the use of the death penalty, even as restriction and outright abolition took hold in many places in the North and Midwest. Capital punishment offered Southerners an alternative mode of racial subjugation, necessary in the eyes of some white Southerners to restrain what they viewed as a primitive or uncivilized Black population. White Southerners feared violent revenge and property crimes by the impoverished freed population, but above all, they seemed to fear sexual aggression by Black men against white women. As one historian observed, especially in the South, the late 19th century was beset with white paranoia on this topic. These attitudes not only supported the use of capital punishment, but also prompted rampant private violence against the newly freed Black population, resulting in what historians have described as a, quote, reign of terror and an orgy of racial violence during Reconstruction and beyond. Between 1880 and 1930, more than 3,000 lynchings of Blacks were recorded in Southern states, where the vast majority of such events took place. During the heyday of lynch mob violence in the 1890s, there were actually considerably more lynchings than legal executions. The uncontrollable mob violence unleashed in lynchings posed an unmistakable threat to the power of the government, and it came to be seen as an embarrassment, a black eye to the states in which it flourished. Hence, many Southern politicians, including relatively progressive Southern politicians, favored retaining capital punishment and for streamlining the capital process to yield very speedy and certain executions in order to prevent lynchings. The quickie trials that resulted, with local sheriffs and prosecutors assuring angry mobs that the usually Black defendant would be hanged by sundown, came to be known as, quote, legal lynchings. And it was this practice in the South that first woke the Supreme Court from its slumber on the issue of capital punishment. In 1931, in Alabama, in an infamous case of the so-called Scottsboro Boys, 9 young Black men and boys who were accused on extremely scanty evidence of raping 2 white women who were riding in the same rail freight car. They were quickly charged, tried, and sentenced to death after having been afforded virtually no legal representation. The case was so flimsy that the state of Alabama eventually issued an official pardon, although 82 years later in 2013. 1 year later, however, in 1932, the Supreme Court issued its first constitutional ruling regarding state death penalty practices. The court held that in capital trials, defendants were entitled to representation by counsel, a holding it would not extend to non-capital cases until 1963 in the famous Gideon versus Wainwright case, a case memorialized by Pulitzer Prize-winning journalist Anthony Lewis in his book Gideon's Trumpet, later made into a movie starring Henry Fonda as Gideon. The Supreme Court's holding in the Scottsboro Boys case turned out to be a shot across the bow, not just with regard to the right to counsel, but also for the American death penalty, an early warning of the reasons for the Supreme Court's eventual full-scale intervention more than 30 years later. In the 1960s, the civil rights movement brought the issue of racial injustice in the South to the forefront of national debate. The 60s were also a period in which the practice of capital punishment was on the wane in many parts of the United States and in other places around the world, but not so much in the American South. The broad scope and racial discrimination that still characterized the death penalty in the South drew the Supreme Court's attention again, or at least some of the court. Justice Arthur Goldberg and his young law clerk, my colleague Alan Dershowitz, wrote a memo to the rest of the court seeking the additional 3 votes they needed for the court to grant review on a death sentence meted out to a black man convicted of raping a white woman in Alabama, shades of Scottsboro. The idea was to challenge not just this one death sentence, but the excessiveness of the death penalty for the crime of rape, which was largely restricted in law to the South and in practice to black men convicted of raping white women. Justice Goldberg and Alan Dershowitz got only 2 of the necessary 3 votes, but he took the unusual step of publishing a dissent from the court's failure to grant review, a dissent that inspired the NAACP Legal Defense Fund, known as LDF, to launch a constitutional litigation campaign to challenge the American death penalty. The LDF was the same civil rights organization that less than a decade previously had, spearheaded by Thurgood Marshall, won the landmark school desegregation case of Brown versus Board of Education. It was the South's racially charged use of capital punishment that led the nation's leading civil rights organization to take on the death penalty as an issue of racial justice. The LDF worked in conjunction with the ACLU and its state affiliates to challenge the death penalty around the country in the 1960s and early 1970s with remarkable success. They managed to achieve a moratorium on executions that lasted a decade, from 1967 to 1977, the longest period in American history without an execution. The LDF lawyers won their biggest victory in 1972 with the landmark case of Furman versus Georgia, in which the Supreme Court struck down the death penalty as it was then practiced in 40 states and the federal government under the 8th Amendment of the Constitution, which prohibits cruel and unusual punishment. Here's the New York Times announcement of that decision. And you can see there's a lot of other stuff happening. Every time I show the slide, people read all the other news that was happening that day. This is the New York Times announcement of that decision with a banner headline as wide as when, equally improbably, the United States landed the first man on the moon 3 years earlier. Furman's constitutional abolition was short-lived, however. The rationale of the decision appeared to be concern about the fact that juries had unfettered, standardless discretion in their sentencing decisions, without any guidance from state statutes to prevent arbitrariness and discrimination. There was a huge backlash to Furman, especially in the South. And many states drafted new capital statutes providing greater guidance to sentencing juries with lists of aggravating and mitigating factors that are now familiar to us today. In 1976, 4 years later, the Supreme Court granted review of 5 of these new statutes from Georgia, Florida, Texas, North Carolina, and Louisiana. And it upheld 3 of them that offered what the court deemed to be adequate guided discretion. And the American death penalty was back in business. The very next year, the first person sentenced under one of these new statutes was put to death when Gary Gilmore waived all of his appeals and was executed by firing squad in Utah, as memorialized in Norman Mailer's Pulitzer Prize-winning book, The Executioner's Song. At first, the Supreme Court's imprimatur seemed to bolster the death penalty. More and more states sentenced more and more people to death throughout the 1970s, 80s, and 90s. And executions surged as well until the end of the 1990s, when death sentencing and execution rates reached peaks not seen in 50 years. But then, as the century turned, death sentencing rates and execution rates began to free fall. This is executions by year, and you can see from the peak, here it is, in the late 90s to 2013, and 2014 is similarly around there. Death sentences down by more than half. That was executions. This is death sentences, and you can see once again the peak here, death sentences down by more than 2/3. Perhaps even more surprisingly, state legislatures began to vote to abolish the death penalty. In the past 8 years, 6 states have voted to abolish, completely repeal their capital statutes, the most active period of death penalty abolition since the early 1960s. We believe that these various declines are in large part also a product of the Supreme Court's regulatory project. By insisting that juries consider all mitigating evidence and that capital defense lawyers be responsible for investigating and producing such evidence, the court has both raised the cost of capital trials and decreased the likelihood of death sentences being imposed by juries who hear these mitigating presentations. And by developing many other special new rules for capital trials, the court has produced more extended appeals and many more reversals and retrials, lengthening the average time spent on death row to 1 to 2 decades, and also increasing the cost of maintaining capital punishment and decreasing the likelihood that a capital sentence will stand. Finally, the sheer complexity of the death penalty doctrine created by the Supreme Court has led to the creation of a specialized capital defense bar that simply did not exist in the pre-Furman era. A bar, a group of lawyers that, like the LDF, works in a coordinated fashion to promote constitutional challenges to the death penalty. As a result, we stand at a moment when the numbers of death sentences and executions are now at the lowest point they have been in several decades and showing continued downward momentum. Which brings me to my third and final topic. Will the American death penalty ever be abolished completely? And if so, when and how? I get this question a lot, and 10 or 15 years ago, I would have answered that the United States will not see nationwide abolition in my lifetime or even my children's lifetime. Now, however, things have changed sufficiently that I predict that national abolition is a real possibility. I'd even say, I'm going out on a limb here, more likely than not to occur, and to occur within the next 20 years or so if things continue on their current course. That said, nationwide abolition will not occur the way it has most commonly occurred in Europe, through legislation. That is because in the American federal system, individual states are the relevant lawmakers, and achieving legislative abolition in all 50 states is simply a pipe dream. While I expect to see more states abolish the death penalty in the near future, perhaps New Hampshire, Kansas, Nebraska, or Oregon, among others, states like Texas and Alabama are not going to abolish the death penalty anytime soon, not in my lifetime and not in my children's lifetime. Which means that nationwide abolition will have to come the way it came briefly before in the 1970s, by constitutional decree from the Supreme Court. What makes me think that such a thing is remotely likely? Well, as part of its constitutional regulation, which has been an ongoing project since the court brought back the death penalty in 1976, the court has developed a new doctrine, a proportionality review, specifically for capital cases, and it has used this doctrine aggressively to limit the scope of the death penalty. 1 year after the 1976 cases, the Supreme Court did what Justice Goldberg and Alan Dershowitz had wanted it to do in the early 1960s. It abolished the death penalty for the crime of rape. Using the doctrine it developed in that case, in the past dozen years, the Supreme Court has abolished the death penalty for offenders with mental retardation, or what we now call intellectual disability, for juvenile offenders, and for any interpersonal crimes other than murder. In deploying this new proportionality doctrine, the court has primarily looked to what it calls objective evidence of an emerging social consensus, in particular to legislative decisions and the results of prosecutorial charging and jury verdicts on the ground. So if we look at these objective indicia for the death penalty as a whole, rather than for a specific practice like the death penalty for juvenile offenders, we see here before you a growing swell of legislative decisions in favor of wholesale abolition and a major decline, as I've showed you before, in both death sentencing and executions. Moreover, in addition to raw numbers, the Supreme Court has also looked at how widespread versus how concentrated a practice is. And in the context of capital punishment, the state level is not the right place to look for this, because even within really vigorous death penalty states like Texas, only a tiny fraction of, say, Texas's more than 240 counties are responsible for the vast majority of executions in that state. A recent study called the 2% death penalty has documented that a majority of death sentences and a majority of executions since 1976 have been produced by only 2% of the nation's counties. But even more favorable to the case for abolition, the Supreme Court has supplemented its objective, numbers-driven analysis with what it calls additional evidence of a social and professional consensus, which includes the following: the views of organizations with germane expertise, the views of religious groups, the views of the world community, and polling data. So let's just consider what evidence of this kind might exist to bolster a consensus against the death penalty. First, let's consider groups with germane expertise. The nation's two premier legal organizations, the American Bar Association and the American Law Institute, have both expressed serious reservations about the death penalty in recent years. The ABA voted in favor of a nationwide moratorium on executions in 1997. It's almost 20 years, which it has not lifted. And in that time has been studying whether states have improved their capital processes with dismal findings of insufficient improvement to justify lifting the moratorium. The ALI voted in 2009, based on a report that my brother Jordan and I were commissioned to write, to withdraw its support from the model statute that it drafted in the 1960s that served as the template for modern capital punishment statutes, citing, quote, current intractable institutional and structural obstacles to ensuring a minimally adequate system for administering capital punishment. In other words, as the New York Times reported, the ALI thought, quote, the death penalty was broken and it can't be fixed. Religious organizations, gotta love the Pope. As for religious groups, many religious organizations have supported restrictions on capital punishment, although, to be honest, only the Catholic Church, as well as Jews and Quakers, are longtime reliable proponents of complete abolition. You might think these are not very compelling religious denominations given their distinct minority status in the US. But I would just point out that among the 9 Supreme Court justices, there are 6 Catholics and 3 Jews. So I'll just leave that there. As for the world community, as I noted, the US remains alone among our peer nations, the other Western industrialized democracies, to retain the death penalty. And the European Union routinely files friend of the court briefs in death penalty cases before the Supreme Court to register its condemnation of the continued practice in the United States. Finally, polling data. The Gallup polling organization has been asking the same death penalty question the same way for almost a century. So we can pretty accurately track changes in public opinion. As you can see, support for the death penalty rose after the Supreme Court's intervention in the 70s, but it has been falling since the late 1990s, and opposition to the death penalty has been rising. Just a few days ago, a Pew Center survey found support for the death penalty at 56% and opposition at 38%, the lowest support and the largest opposition of any poll in the last 40 years. Support dips to below 50% when those who are polled, those being polled are offered the alternative of life without possibility of parole, with the inmate working to pay restitution to the victim's family. So, my point here is that the doctrinal architecture is in place for a possible full-scale constitutional abolition of the death penalty, a Furman II, if you will. But I'd be the first to acknowledge that doctrinal architecture is not destiny. Judges have to be willing to use the legal scaffolding available to them, and judges, let's face it, tend to be a fairly cautious bunch. Nonetheless, this past summer, a federal judge who was appointed to the federal bench by George W. Bush declared the California death penalty unconstitutional on the ground that the death penalty was so rarely carried out after such long delays that it can no longer serve any possible penological purpose, drawing, in its language, on the Supreme Court's proportionality cases. Now, while this particular decision is, I think, unlikely to be upheld on appeal, it represents a first step toward wholesale federal constitutional questioning of capital punishment. Will this Supreme Court, as currently constituted, be willing to abolish capital punishment under the Constitution if trends continue in their current direction? I think the four liberal justices, here they are, Sonia Sotomayor, Stephen Breyer, Elena Kagan, and Ruth Bader Ginsburg, I think those four would be open to an argument along these lines at the right time if the numbers continue to go where they're going. I'm pretty certain that the four conservative justices, Chief Justice Roberts, Antonin Scalia, Clarence Thomas, and Samuel Alito, would not be open to such a challenge. So that leaves swing Justice Anthony Kennedy, where he usually is, right in the middle. The question mark on this issue. He also happens to be the main architect of the proportionality doctrine that is the, I think, most promising legal argument toward this end. However, as you can see from this picture, Kennedy, along with several other justices on both the left and the right, is no spring chicken. So the answer may well lie in Supreme Court appointments made by the next few presidents, and therefore it might lie in the political branches after all. I close with this thought. Oh, there's the kingmaker, Justice Kennedy. I close with this thought. If nationwide abolition of the death penalty through a Furman II type decision does occur, it will owe a large debt to the brief life of Furman I, which gave birth to the intensive constitutional regulation that sowed the seeds for an eventual successful constitutional challenge. One could describe the Supreme Court's death penalty doctrine the same way a journalist described the work of death penalty lawyers deploying that doctrine, as operating like Shakespeare's Portia, who didn't protest at the barbarity of cutting a pound of flesh from the Merchant of Venice's side, but raised so many caveats. No blood must flow, the flesh must weigh precisely 1 pound, no more, no less, that she made the unspeakable impossible. Thank you.
Thanks for a wonderful talk. I'm just wondering the extent to which you think DNA has changed the story, because not only that the DNA analysis has changed the story, but there are organizations that are specifically dedicated to look at the evidence of cases where there are real questions about the evidence being used to sentence somebody to death?
That's an excellent question, and I think a very important insight. You saw, going back, that free fall, declining death sentences and declining executions, but particularly death sentences since the late 1990s. The late 1990s is essentially the era of the so-called DNA revolution, which has brought to the attention of the public the fact that many more sentences, both capital and convictions, non-capital convictions, were erroneous, and as cases that looked very strong. Some witness said, "I'm sure that's the person," and then it's really not the person according to the DNA. So that, I think, played a big role in making people question capital punishment. And so to some extent, that's in some ways in tension with my story, which wants to say that a lot of this free fall has to do with the Supreme Court and its doctrine. But I think those two things are related, is that the Supreme Court has put a lot of new duties on capital defense lawyers, and it's that bar that has been very active in pushing DNA exoneration. And some of the most dramatic exonerations were in capital cases. And in fact, in the early 2000s, Republican Governor George Ryan of Illinois declared mass clemency on Illinois' death row after a series of exonerations of people on death row based on DNA and some non-DNA exoneration. So I think that's a huge part of this story of the decline, connected with the sort of organized bar that's hunted down this evidence and brought it to light. So I think that's an excellent point. Catherine.
Yeah, terrific talk, Carol. Thank you. Can you say a little more about the role of world opinion? You made it seem like only the European Union mattered, and is including the impact of world opinion on the Supreme Court justices themselves, some of whom do interact with their colleagues in the rest of the world and are very criticized for the U.S. position on the death penalty. In many parts of the world, when we're looking at this kind of norm change, it turns out that the biggest explanation is not what happens inside a country, but what the majority of the neighboring countries are doing. We tend to think the United States, U.S. exceptionalism, the rest of the world doesn't affect us, but I'm wondering whether there's an alternative story, and that is U.S. abolition of the death penalty is going to happen because in the end we won't be the only standout from the rest of the world.
I think that's a really excellent question. I emphasize the European Union simply because the court does. So this is the footnote. This was in the first of Justice Kennedy's cases that talk about these additional considerations that go into establishing whether there's a consensus. And this footnote cites to a brief from the European Union as friend of the court, amicus curiae. So, we tend to think, and then in the next case, this was the case involving where the Supreme Court said you couldn't impose the death penalty on people with cognitive disabilities, intellectual disabilities. The very next case, the world opinion made it out of the footnote and into the text. And there was a ringing statement, but particularly it was kind of like countries like us, other democratic, constitutional democracies, we should be particularly interested in their experiences and what they think really matters. So the Supreme Court, I think, has put a big emphasis on this, and in particular to our peer nations. Now, there may be behind this, I think, some concern about, the internationalization of criminal law enforcement and investigation. And there are other countries among our allies who will not extradite to us if the death penalty is on the table. And so I think there's potential support from law enforcement organizations who would be very powerful voices against the death penalty if it got to a point where it was really affecting our ability to do joint investigations and get extradition from our allies. But I think that's an excellent point.
So you stated that the use of the death penalty has always been motivated or fueled by political forces. I guess abolition by legal considerations, but application by politics. And I'm wondering about the politics behind the present capital case that's playing out here in Boston. It seems to me provocative even for the Obama administration to impose a capital case, capital trial on a state that for a generation has abolished the death penalty by popular vote, by a referendum. And there have been repeated polls, that was mentioned, one poll was mentioned, but there have been many, that indicate that Massachusetts residents, Boston residents are opposed to the death penalty in general, and very much opposed to the application of the death penalty in this particular case. So I'm curious about what's behind this, and also how it works out legally that in order to be a member of the Tsarnaev jury, you had to be in favor of the death penalty. In favor, not opposed. In favor of the death penalty. That is a minority of Boston residents, a minority of Massachusetts residents. This jury does not speak for me or the majority of people in this room. How does that work?
Well, to take your last question first, it's not exactly the case that you have to be in favor of the death penalty to sit on a capital trial. The question is that the specific legal standard is the judge has to determine that the person's prospective jurors' views about the death penalty would not prevent or substantially impair their ability to serve as a juror. So they have to be able to say that they would not, if they say I could not consider the death penalty before I hear any evidence, no matter what the evidence is, I could not consider the evidence, they can't sit. But similarly, someone who says no matter what the mitigating evidence is, if I find the defendant guilty of this crime, I would automatically impose the death penalty, they also can't sit. So it's not a matter of for or against. They have to be willing to consider both potential punishments. So that's the legal standard. Why the federal government would seek a death sentence in a state that doesn't have the death penalty is, a good question to ask. It's done a lot by both Republican and Democratic administrations. And it arises from the kind of weird metaphysical duality of the fact that Massachusetts is both a sovereign state and part of the United States of America. So as citizens of the sovereign state of the Commonwealth of Massachusetts, we don't have the death penalty. As citizens of the United States of America, we do have the death penalty. So the government stands up and says, we're the United States, meaning we represent all of you, everyone who's in the United States, and we want the death penalty, and our government has the death penalty. So, it's challenging, and it should be challenging to get a death sentence here in Massachusetts. In recent years, it's been difficult. There was a capital case, several years back, where the government sought the death penalty for Kristen Gilbert, a nurse in a VA hospital who killed several patients, and the jury did not give the death penalty in that case. They gave life. But also several years back, Gary Sampson, a guy who killed several people here in Massachusetts, the federal government sought the death penalty, and they got a death sentence for him, although that case was reversed on appeal and will be retried, and the federal government will again seek the death penalties. Now they've put the case off because they've got one going on right now till September. So that's another federal death penalty case that will be retried here in Massachusetts in the fall. I think that the federal government will be looking to see what Massachusetts juries do in these cases, and that may well determine the likelihood of future death cases in the Commonwealth. Bruce.
I thought this was a terrific talk as well. So my question is about race, and you showed totally convincingly for me how important race has been for the history of capital punishment, and racial conflict has been important for the history of capital punishment, and yet it seems to be we seem to be in a place now with the evolution of the courts thinking that in this post-Furman world, the issue of race seems to be virtually eradicated from how the court is thinking about this. But then I look at the reality of what death rows look like and what victims look like, there seems to be a mismatch between the kinds of debates that are evolving now in the court and the reality of capital punishment as it's still practiced. Is there any prospect for the court revisiting that in some way, or for that reality to figure in its thinking in some way?
That's a great question. So great a question, Bruce, that an entire chapter of our book is devoted to that question. It's called the Supreme Court and the Invisibility of Race. And it talks about why it is that given, this is the LDF, this is Thurgood Marshall's law firm that's litigating these cases to the court, to Thurgood Marshall in the early 1970s. This is in the middle of school desegregation, battles that are, the civil rights movement and school desegregation on TV every night. And you read the foundational cases of the Supreme Court, and if you were a Martian, you would never know that really race had anything to do with this. The court really stands on its head to avoid talking about these cases as race cases, even though the litigation papers are, race, 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 race. So I think the court, part of it was early on, Earl Warren didn't want to imperil school desegregation by, little black school children were a lot more appealing than people on death row. So he didn't want the death penalty to be the racial issue that the court dealt with as a racial issue. So, part of it was the liberals trying to win hearts and minds, and they didn't think they were going to do it with convicted murderers and rapists. So that was part of the story. And eventually, as the lawyers in the room know, the Supreme Court eventually did take on the question of race in a case called McCleskey versus Kemp, in which a very careful statistical study of the death penalty in Georgia showed that the race of the defendant and the race of the victim, actually even more powerfully, the white race of the victim, black race of the defendant, played a big role in determining who got the death penalty. And the Supreme Court said, well, statistics will never win this case for you because you're going to have to show, under the Constitution, to win a race challenge, you're going to have to show that the jury in your particular case acted for discriminatory reasons. And you can't show that just by showing statistics that every other jury in this county did, or over a long period of time. So, where are you going to get that kind of evidence? You need a smoking gun. So basically that standard is insurmountable. Do I think the Supreme Court will revisit that standard? No, I don't. Do I think that race in the background will be an important background consideration? I think it was an important background consideration in the foundational cases. And ironically, by contorting itself to not rule on the basis of race, the Supreme Court came up with all these other rules, the sort of Portia, gotta only 1 pound and, can't have too much blood. They came up with all those rules, and it's those rules that are gonna bring down the death penalty, although they weren't intended to. So it's one of the ironies, and there's a little historical irony too, that in passing the 14th Amendment to the Constitution, the sort of, more radical drafters wanted to put race in the 14th Amendment. You can read the 14th Amendment. It doesn't say race. It says, that citizens are not to be deprived of equal protection of the laws. And by avoiding saying race, guess who's getting to take advantage of the 14th Amendment? Like women, and gay people. And just, that's another example where trying to avoid race has actually led to unanticipated consequences far beyond what either the drafters of the Constitution or the interpreters of the Constitution meant to do. And I think it's the contortions to avoid race that have given us the doctrine that's leading us to where we're ultimately going to go. Jennifer.
Thank you for a wonderful talk, Carol. So I have a question that I want to make clear is not a devil's advocate question, because I do not believe in the devil, and if the devil existed, I do not think that she would need my advocacy. It is a sincere question, and partly one because I'm mystified by the arguments for the death penalty. And so I wonder, what are the best arguments today, or perhaps historically, that for the legality or the ethics? Well, it has to also be the legality of the death penalty. And what are the most formidable? Is there evidence? I mean, what continues to recommend it other than prejudice and ignorance and fear? And if the answer is none of them are formidable, they just then. If you could show me, if you could just kind of tick off, here are the sort of operative big arguments for, and here's why they are wrong.
Well, I'm looking for Matt Boyle, because as far as the moral arguments go, Kant is like the biggest, he's the granddaddy of sort of, and many people think of sort of moral philosophy of American criminal justice, the sort of proponent of retributive justice, which many people think, oh, you're just talking about baseless vengeance. But no, I'm using the sort of philosopher's idea of retributive justice, which says people should be punished to the extent of their moral desert. And death, Kant is famous for the sort of desert island hypothetical. He said if all of society were about to end, and we're on a desert island, and society were about to disband, and never exist again, that society would have a moral obligation to execute its last murderer, because he felt that only execution was proportional punishment for a murderer, that anything else would be disproportionate. So the Kantian challenge is if you believe in punishment proportional to the crime, why isn't death the only proportional punishment for murder? Now, I have to say, I get asked to debate the death penalty a lot, and that is almost always the opening line. If you want my answer, I'll give you my answer, because I'm not going to let Kant take the stage and nudge me off. But usually I'll give you the most dramatic version of this. Like one time, about a decade ago, I was asked to debate a former federal prosecutor who described this horrible case where a guy and his girlfriend broke up, and he kidnapped her 2 children that were not his children, and he tied them up and staked them out in an alligator swamp to let them be eaten alive by alligators, which they were. And this prosecutor said, how could you punish this guy with anything less than death? Anything less than death would be a joke in terms of what this person deserved. Now, I have tried to find this case. Westlaw searches for alligators and children, and I have not been able to find this case. So I think he might have made it up just for rhetorical purposes. But here's my answer, is what makes us think that one relatively painless death would be proportional punishment for this guy? Why don't we stake him out in an alligator swamp and let the alligator eat him half to death because he killed 2 people, and then patch him back up and stake him out again and let him be eaten to death? Now, always when I do this, I see some people in the audience nodding and yeah, it is a good idea. But most people, oh, there's Matt. Most people, even those who support the death, say, well, we don't do that. I mean, we're not civil. That's not civilized. It's just we're not the kind of people who do that kind of thing. Well, then I say, well, now you're on my page, because if what people deserve in some abstract sense and what we're willing to do to them diverge, then you've got to tell me why killing people is not one of the things that we shouldn't do to people. So that's I think the biggest moral argument. Then people debate the deterrent question. Does it deter? There isn't a lot of good evidence that it does. The legal argument is actually very powerful in favor of the death penalty. The original Constitution mentions the death penalty all over the place. You can't be deprived of life, liberty, or property without due process of law, meaning presumably you can if there is due process of law. It refers to capital or otherwise infamous crimes. It says can't be held twice in jeopardy of life or limb, even seems to presuppose corporal punishment too. So if you're a strict originalist, this is Justice Scalia, says it in the Constitution, so clearly it's not unconstitutional, then it's just up to the political branches. You know, you don't like the death penalty, go get your reps to vote against it. So it's a big change, you know, but the Constitution also says no cruel and unusual punishments. And the Supreme Court has said, you know, what that means changes over time. So it used to be fine to execute juvenile offenders, not so anymore. It used to be fine to execute people with intellectual disabilities, not so anymore. It used to be fine to execute people for all kinds of crimes, including heresy and adultery and being a rebellious son. It's, you know, not fine anymore. So things change, and really the question is, will the death penalty ever be taken off the table? But yeah, I think there are legitimate arguments about this, and I think winning hearts and minds is the way to go, which is why I never turn down an opportunity to debate anyone. So students, keep that in mind. Yes?
Hi, so thanks,
Oh, sure.
Carol. Hi, thanks, that was excellent and also very helpful to me personally. I guess I had two related questions, which are about what is it that we're talking about exactly when we talk about abolition of the death penalty, right? So as you were going through the sort of, you know, the periodization there, and then you ended with where we are today, it seemed to me really familiar, and it sort of, you know, dawned on me that we've already been there, as it were, right? The 1960s, you know, fairly low support for the death penalty, declining executions, which then leads to Furman. And so if we take that and go to sort of Furman 2, why wouldn't we get another backlash? Because it also seems to me that, you know, you mentioned one major difference between how abolition happened in Europe and how it might happen here, which is legislative versus legal. The other major difference, it seems to me, is that any Supreme Court decision, almost by definition, is going to be of sort of a temporary evolving nature, right? Things change, whereas in Europe, abolition is definitive, it's permanent, and now it's anchored in the laws of the European Union, so that there's no out. So I guess the question, that first question is, what happens after Furman 2, right? How do we maintain abolition if indeed we're talking about abolition? And then I guess the second question is related to that, in that no, I sometimes wonder if we're talking about abolition or we're talking about reform, and you actually sort of go through these changes over time. But won't there always be a Tsarnaev? Won't there always be these heinous crimes for which exceptions, you know, should be made, even though, you know, we say the death penalty is off, except the emphasis that abolition is often put on issues of innocence, the methods of execution, you know, the racial bias. So, you know, a reform project of the death penalty, it seems to me, really making sure that only really truly guilty people are executed, right? That the methods of execution are as humane as we can make them, and we make it racially equal, right? So would that not satisfy sort of where this whole movement has been going to? So what does abolition mean for you? Thanks.
Right. Well, both excellent questions. As for the reform rather than abolition, I think the best answer is the American Law Institute's answer. They are the premier law reform organization. They brought you the restatements of law, which are all you law students will know are used by courts. They did the model penal code. They're big into, if there's a problem, we will fix it through our expertise. And so when people in the ALI wanted to have them withdraw their support from the model penal code death penalty statute, which served as the template for the modern death penalty, a lot of other people said, we're the ALI, we'll just fix it. Just tell us what the problems are and we'll fix it. And so Jordan and I wrote the report to them and said, well, you know, if you want to fix it, you're going to have to fix a few things. Like you're going to have to fix the fact that most states elect their judges and prosecutors. And judges run on how many people they've put to death in their courtrooms. You're going to have to fix the fact that there's not enough money to pay for decent defense lawyers, which are paid for county by county in most states. You're going to have to invent public defender services, say, in Texas, where they don't exist. And you're going to have to deal with the problem of shoddy, forensic science and police investigations that have led to all of these innocent people on death row, which is not anything that the ALI has any control over. You can't pass laws that say to the states you can't elect your officials anymore. States get to decide that. So the ALI kind of reluctantly said, you know what? We are going to withdraw our old statute, and we're not going to even try to pass a new one because the problems are intractable to law. So that's the answer on the reform front. On the why not a backlash, Jordan and I have gone back and forth on this because it's true, there was a tremendous backlash to the Furman decision, and why wouldn't we expect the same thing from a Furman 2? The answer is what we hadn't had in 1972, which we have had now, is a long period of attempting to regulate the death penalty without success. And so, the court's ruling in 1976 was, mend it, don't end it. These new statutes should work. Let's see how they go. We'll tinker year by year. And now we could say, look, the Supreme Court tried, and we're still seeing racial disparities, innocent people on death row. You fill in your concern, it's there. And I think that might work against a kind of backlash. Plus, you have to say, go back to that New York Times thing, 40 states had the death penalty in 1972. Already, we're down to 32. And I think that's why I don't think we're at the moment yet, but we're getting into the realm of, when we're getting into the sort of mid-20s, we're talking half and half, and I think that's a substantial thing. Plus, we're seeing much, much greater concentrations within states, the 2% death penalty, which was not the case in 1972. Last quick question.
Yeah, quick comment. I can't wait for the book. So I was wondering whether the retention or reinstatement of the death penalty in the United States has helped abolition in other parts of the world. Speaking as an outsider, for most of the world, I suspect the United States is the much loved barbarian, and I know as a fact that sort of racial relations and the struggle against affirmative action in the United States has helped racial relations and the advocates of affirmative actions in other countries. I know it's an empirical question. I don't know the answer for that, but I was just wondering whether a lot of the abolition that has happened in the last 40 years is actually thanks to the reinstatement by the Supreme Court here. So that is a comment. The quick question is, you show the sort of doctrinal architecture as a piece of judicial statecraft. The Supreme Court places the tracks that will register evolution of public opinion so that when the abolition comes, the backlash is not to be feared because the population culturally is going to be there already. But I was wondering, what is there to fear if they have the 5 votes? What is there to fear in abolishing now? It's not like abortion where there is so much regulation that will continue to occur. And sometimes it's equal, conflated with the sort of backlash in abortion law. So what do you think is feared by Justice Kennedy or the 5 votes that put in place the architecture here? Why not abolish it altogether?
Yeah, that's excellent questions. I mean, I think what the court fears is a loss of legitimacy. There's always the critique about activist courts taking over what properly belongs in the legislative branch, and I think it's that accusation that the court fears. And I'm going to end on one of my favorite stories, which responds to, has the United States retention of the death penalty actually driven abolition in other countries. At the end of apartheid in South Africa, the very first case, the South Africans created a constitutional court that would interpret its brand new post-apartheid constitution. In the constitutional drafting process, the drafters were unable to agree about what to do on capital punishment, so they said nothing about it. South Africa before apartheid, in apartheid South Africa, they had capital punishment, have this spanking new constitution, doesn't say anything about death penalty one way or the other. The very first case argued before the new Constitutional Court was a challenge to the South African death penalty. And the arguments are going on in front of the justices of the new South African Constitutional Court, and the proponent of retention of the death penalty in the new South Africa waives, it's 1995, I think it's 1995, when New York State brought back the death penalty for the first time post-Furman. They brought the death penalty back in 1995. Governor Pataki signed it into law in 1995, and this is back in the days, I might have to explain to you what this is, of fax machines. And the lawyer for the state is arguing, you know, I'm holding in my hands a fax from New York. Governor Pataki has just signed into law the death penalty back in New York State, you know, sort of arguing that the winds of change were toward retention rather than abolition. And the Chief Justice of the South African Constitutional Court drew himself up and said, "Counsel, this is not New York, this is South Africa." You know, when I think of the protest marches, hey, get the word, this is not Johannesburg, it's like delicious irony. This is not New York, this is South Africa. So there you go. Thank you very much.